Okay, good afternoon, everyone. Welcome, everyone, to the second panel of this conference. I'm András Köblös from the University of Public Service, and first I would like to thank to the kind invitation to Professor Szilágy János Ede and Zoltán Tóth. There will be 3 lectures in this session with the following topics and speakers: Dr. Adél Köblös, Senior Research Fellow of the University of Public Service, Budapest, about the European Court of Human Rights judgments in the decisions of the Hungarian Constitutional Court. The second will be Dr. Slobodan Orlovic, full professor at the University of Novi Sad. The influence of attitudes of the European Court of Human Rights on the practice of the Constitutional Court of Serbia. And Associate Professor Dr. Benjamin Flander, Associate Professor, University of Maribor, the constitutional review of COVID-19 restrictions in Slovenia. I would like to inform the speakers that you have 20 minutes to give your presentation. I printed 3 sheets, so I'm going to show you the sheets. Okay? Right in time, so sorry, but... Okay, now first, I would like to ask our first speaker, Dr. Adél Köblös, to present her lecture within not more than 20 minutes. I give you the floor. Thank you.
Thank you very much, Professor Köblös. I try to do my best and keep the time frame. And as you have already heard, the title of my presentation is European Court of Human Rights Judgment in the Decisions of the Hungarian Constitutional Court. While I was thinking about a good title, but after a while, after some months, I have to admit that it sounds a bit weird. Anyway, I would like to speak about the impact of the European Court of Human Rights Judgment on the jurisprudence of the Hungarian Constitutional Court. And I would like to approach this field, this issue, from a broader perspective. And therefore, you can see you can read a sentence quoted from the research design, and it was in the research instructions elaborated by Professor Tóth, and it sounds as follows. For this, it was necessary to determine which arguments appear typically in the practice of the given constitutional court, whether they are decisive, defining, strengthening, or simple arguments or simple illustrations with marginal significance. I faced a great challenge in this research project to answer this question, because I looked at the arguments, the reasonings of the Hungarian Constitutional Court, and actually the text didn't help me to answer this question. The Constitutional Court quite often uses very weird and general terms. For example, it took into account, for example, the case law of the German Constitutional Court, or presented the judgments of the European Court of Human Rights, or examined the case law of the US Supreme Court. And under these phrases, I was unable to identify the weight the Constitutional Court attributed to these different methods of interpretation. Even though I found some partial declarations about this the role the different methods of interpretation play. For example, in one of the decisions, I read that the Constitutional Court primarily took into account the case law, its own case law, and secondly, the judgments of the European Court of Human Rights. Nevertheless, I couldn't answer this question, and even if you can read statistics at the end of my part, don't be sure that those numbers are correct, because it would be possible that I recount the different ways of different arguments. I would come to another conclusion. And actually, I decided to look at one of the methods of interpretation and reanalyze the 30 selected decisions in order to be able to answer these questions. So I turned to and decided to focus on the judgments of the European Court of Human Rights for two reasons. One of them was that one of the selection criteria was that each decisions of the Hungarian Constitutional Court selected had to contain a substantive reference to at least one judgment of the European Court of Human Rights. And on the other hand, I explored that there is a very ambivalent attitude from the Hungarian Constitutional Court to the judgments of the European Court of Human Rights. And therefore, I reanalyzed these selected judgments, focusing on the judgments of the European Court, references to the judgments of the European Court of Human Rights. Nevertheless, I didn't want to focus on particular fundamental rights, so I didn't want to discover the case law relating to the freedom of expression or the right to fair hearing, etc., etc. I wanted to have a general impression about how the Hungarian Constitutional Court applies the case law of the European Court of Human Rights. First of all, I would like to go back to the beginning of the function of the Hungarian Constitutional Court, when the main resource of reception concentrated around the German Constitutional Court's case law and that of the US Supreme Court. And there was a shift, there was a change to this practice in the 2000s when this reception has shifted to the reception of the case law of the European Court of Human Rights. So by the time the new fundamental law entered into force, a large body of the European Court of Human Rights case law had been the part of the Hungarian constitutional reasoning. And there was a debate between the constitution maker and the Constitutional Court in 2010, in 2011, and I cited here quoted a part from the reasoning of Decision 61 of year 2011. It said that for certain fundamental rights, the Constitution defines the essence of the fundamental rights in the same way as an international treaty. For example, the Covenant on Civil and Political Rights and the Human Rights, the European Convention on Human Rights. In these cases, the level of protection of fundamental rights provided by the Constitutional Court cannot be lower than the international level of legal protection based on the principle of pacta sunt servanda, so it's an international principle, even it's reflected also in the Constitution and in the fundamental law. The Constitutional Court should follow the Strasbourg case law and the level of protection of fundamental rights, even where this wouldn't necessarily stem from its precedent decisions. So this was a clear declaration how the Constitutional Court looks at the judgments of the European Court of Human Rights. And actually, this declaration was also reinforced under the fundamental law. And later on, it was reworded in the following way. The Constitutional Court accepts the level of legal protection provided by international legal protection mechanisms as the minimum standard for the enforcement of fundamental rights. It refers mainly to the case law of the European Court of Human Rights. This is, I would say, the minimum standard doctrine or the minimum standard requirement. And even though all selected decisions contain a reference to at least one judgment of the European Court of Human Rights, this statement can be found only in 7 or 8 decisions out of the 30 decisions. I would like to turn to one of a very interesting decision. It is decision 4 of 2013, where this minimum standard requirement was repeated. And the Constitutional Court made it clear that although the judgments of the European Court of Human Rights have declarative effect, so they don't bind the Constitutional Court, its case so can help in the interpretation of constitutional rights declared in the fundamental law or international treaties and the assessment of their scope and content. And it confirmed that the level of protection provided by the Constitutional Court cannot be lower than the protection provided by the European Court of Human Rights. But if the Constitution provides for a higher protection, then this higher protection shall be provided by the Hungarian Constitutional Court, even though the European Court of Human Rights level of protection is lower. This case is very important for other reasons, and I would like to say some words about that this approach is not unanimously accepted by the justices. There are justices saying that the judgments of the European Court of Human Rights have only informative role, and they are only legal opinions, and suggest that references to these judgments should be only in the draft decisions for in-house use only, and they shouldn't be in the decisions, in the final decisions. Nevertheless, it is still in consenting opinions yet. Who knows, maybe it will be changing in future. Let's say some words about my impression. I have already mentioned that even after the reassessment of the 30 selected cases, I cannot answer the original question under the research design. Nevertheless, the assessment helped me to get closer how the Constitutional Court applies the case law of the European Court of Human Rights, and I can confirm that this attitude is still quite ambivalent. There are common cases, common cases where the same legal and factual issue comes before the European Court of Human Rights and also the Hungarian Constitutional Court. And when the Hungarian Constitutional Court made its own assessment, the judgment of the European Court of Human Rights was already available for it. There are 2 decisions out of the 30 you can see on my slide. One of them is decision 4 of 2013, where the Hungarian Constitutional Court had to reassess the constitutionality of a statutory rule. It was a criminal code provision. Actually, the constitutionality of this provision had been already assessed before, and on the basis of the fundamental rights, the freedom of expression mainly, the Constitutional Court didn't find a violation. And the Constitutional Court in its previous decision found its reasoning on the case, though, and it referred to different judgments of the European Court of Human Rights. Nevertheless, later on, the European Court of Human Rights changed its approach and took into account further circumstances in the development of the history of Hungary. And the same person who instituted a procedure before the European Court of Human Rights, filed a constitutional complaint with the Hungarian Constitutional Court. And in this case, this new approach of the European Court of Human Rights played a very important role in the conclusion of that it's possible to reopen the case, so there is no so-called res judicata, and it reassessed the constitutionality of the same criminal provision. Nevertheless, it based its reasoning not on the freedom of expression, the fundamental right, the freedom of expression, but instead the principle of rule of law. And primarily, yeah, he knows the case. Therefore, he didn't have to confront the previous, its own previous decision, and it didn't have to base its reasoning on the European Court of Human Rights judgment, but it could elaborate a new argument and concluded in the violation of the rule of law principle, legal certainty. It also declared that there was a violation of the freedom of expression, but it was, I would say, a side effect, as a second effect of the violation or of infringement of the rule of law principle. The other case is related to a social security issue, and the Hungarian Constitutional Court suspended its own procedure until the delivery of the judgment of the European Court of Human Rights. And the two fora had to assess the statutory rule of the same statutory rule on the basis of the non-discrimination provision of the European Convention of Human Rights and the fundamental law on the one hand and the right to property. The European Court of Human Rights didn't find a violation, and finally the Hungarian Constitutional Court didn't find a violation either. Nevertheless, the decision of the Hungarian Constitutional Court in relation to the constitutionality of this statutory rule was based on its previous case law. Reference was now made to this judgment delivered by the Grand Chamber. Instead, there was a reference to the judgments of the decisions of the German Constitutional Court. There was a second part of this decision, because the Hungarian Constitutional Court had to examine whether the statutory rule is in harmony with international treaty, namely the European Convention on Human Rights. And actually in this part, one can find reference to the judgment of the European Court of Human Rights. Nevertheless, even in this relation, the Hungarian Constitutional Court didn't find decisive the judgment of the European Court of Human Rights. On the one hand, it said that the Strasbourg Court didn't find a violation, but at the same time, the result of the assessment of the Strasbourg Court didn't deviate from that of the Hungarian Constitutional Court. So even in common cases where the judgments of the Strasbourg Court are available for the Hungarian Constitutional Court, in Hungarian cases, in the same factual and legal issues, the judgments doesn't have decisive character. The next, it's quite common that the Hungarian Constitutional Court adopts dogmatic considerations from the European Court of Human Rights judgments, for example, especially in relation to the freedom of expression, the freedom of assembly, or the right to fair hearing. And I would like to skip this, even though I think that Mr. President prepared this decision. I wanted to share with you. Nevertheless, the Hungarian Constitutional Court refers to the judgments of the European Court of Human Rights, even where the relation between the case before the Hungarian Constitutional Court and the European Court of Human Rights is very very loose. For example, in one of the decisions, the examination before the Hungarian Constitutional Court was carried out on the basis of Article P, which is not a fundamental right, but is about the protection of environment. Nevertheless, the Hungarian Constitutional Court felt necessary to refer to make reference to the judgment delivered in ECtHR versus Romania, which was a case where the European Court of Human Rights carried out its examination on the basis of Article 8, the right to respect for private life. Nevertheless, both bodies accepted the principle of precaution, and the Hungarian Constitutional Court, I think at least, found important to underpin its reasoning by reference to the judgment of the European Court of Human Rights. And even though it seems that in this case the role of the reference was only an illustrative role, nevertheless, I think even in these cases, the aim of the Constitutional Court to underpin its reasoning by reference to the European Court of Human Rights, because it attributes a certain level of authority to the judgments of the European Court of Human Rights, and by this it could explain and confirm that this principle of precaution is accepted not only in national but also in international law and international case law. And finally, the Hungarian Constitutional Court doesn't confront the European Court of Human Rights judgments. What I realize that if the court doesn't want to follow a judgment, then it's just arbitrarily selects the cases or just be silent. No reference is made to the judgment of the European Court of Human Rights. Professor Todt was the drafter of one of the decisions, as I remember. In one of the cases where, even though the constitutional complaint contained a clear reference of the judgment of the European Court of Human Rights, the reasoning was not based on this issue, this judgment. The Constitutional Court referred to its own previous cases, case law, statutory law, general principles, and finally it made a remark and addressed the message to the Supreme Court to take into account the judgment of the European Court of Human Rights, I suppose in order to avoid, to prevent further procedures before the European Court of Human Rights. Thank you for your attention.